If you have a child with disabilities, your estate plan may look perfectly fine on paper while quietly creating problems that could cost them government benefits, disrupt their care, and leave your family scrambling when it matters most. Hi, I'm Jeff Llewellyn. I'm a principal at Rockwood Wealth Management and the practice lead for our special needs planning team. And this is personal for me, not theoretical and not a day job. You see, I'm the father to an adult daughter who is medically complex with numerous disabilities, so I've lived this. And today, I'm going to walk you through the 5 estate planning mistakes I see families make. And they're not the ones you usually hear about, because most estate planning conversations stop at get a will, get a trust. But for families navigating real complexity, that advice barely scratches the surface. Some of these mistakes cost money. One of them can cost benefits. And the real issue is coordination and making sure your family knows how to best care for your loved one. So let's get into it. Mistake number 1, using a general estate plan when your family needs a specialized one. Here's what happens. A family, maybe your family, goes to an estate attorney. You know something has to be done. You get a will, maybe a revocable trust, you get powers of attorney set up, healthcare directives, and you walk out feeling really good because you check that box. And for some families, that actually works. Great job. But here's the thing. For families like yours with complexity, a general plan can quietly create problems you won't discover until it's way too late. I'll give you an example. I sat with a family recently, 2 adult children, one with significant disabilities who depends on SSI and Medicaid. The parents had a perfectly drafted revocable trust. It said everything goes to the kids equally. On paper, looks great. Clean, avoids probate, perfect. But here's what nobody told them. When that trust distributes directly to a child who receives government benefits, it can disqualify them. Not reduce benefits, disqualify them completely. You see, SSI has a strict $2,000 asset limit. Medicaid eligibility has income and resource thresholds, and one distribution from a regular trust can wipe out years, sometimes decades of benefits. You see, the plan was right for one purpose, avoiding probate, but it was wrong for the purpose that mattered most. Now, let me tell you about the second mistake, and this one catches people off guard every single time. Mistake number 2, not coordinating with extended family and other benefactors. This one surprises people. Parents will do the hard work. They'll set up a special needs trust. They'll restructure the estate plan. They'll get everything aligned and titled and everything named correctly. And then a grandparent leaves a direct inheritance. An aunt names the individual with disabilities as the beneficiary on a life insurance policy. A well-meaning sibling or cousin sets up a 529 plan in their name. And one of these can undo years of careful planning. I'll give you a real scenario. A grandmother, loving, generous, leaves $50,000 directly to her grandson who has a disability and receives SSI and Medicaid. She had no idea about the $2,000 asset limit because nobody told her. There were no family conversations. The parent already had a special needs trust in place for their own estate, but they never had the conversation with extended family. Now, the family is scrambling, trying to establish a trust after the inheritance, navigating spend-down rules, working with an attorney to protect what they can. It's stressful, it's expensive, and it was completely preventable. The fix isn't complicated, but it requires a conversation most families never have. Every person who might leave money, think of grandparents, aunts, uncles, family friends, cousins, they need to know that direct gifts to someone who receives government benefits need to go through the right structure. Not because you as the parent, not because you're being controlling, but because you're protecting your loved one. And speaking of the right structure, here's where I see families lose the most sleep, because the terminology alone can make your head spin. Mistake number 3, choosing the wrong type of trust, or not using one at all when you should. Let me simplify something that causes a lot of confusion. A revocable trust and a special needs trust. They serve fundamentally different purposes in most cases. A revocable trust avoids probate. That's valuable, but it does not protect government benefits. When the trust distributes outright to a beneficiary, the money belongs to that person. It goes into their Social Security number and counts against them for any needs-based testing. A special needs trust, sometimes called a supplemental needs trust, is designed specifically to hold assets for someone who receives government benefits without disqualifying them. The trust can pay for things that the government doesn't cover: therapies, education, transportation. Think of quality of life things such as vacation and travel. But it's structured so the assets aren't considered available resources for the individual with a disability. Now, here's the detail most people miss. There's a difference between a first-party special needs trust and a third-party special needs trust. A first-party special needs trust is funded with the individual's own money. Think of an injury settlement or a legal settlement, right? Or an inheritance that came directly to them. And here's the catch. When that person passes away, Medicaid can seek reimbursement from whatever's left in the trust at the end of their life. A third-party trust is funded with somebody else's money. It could be a parent, grandparent, family, friend. And when the beneficiary passes away, there's no Medicaid payback. The remaining assets go to wherever the trust document dictates. That distinction alone can mean the difference between preserving a legacy and losing it to reimbursement claims. The families who navigate this best don't try to figure it out alone. They work with an attorney who specializes in special needs planning, not just general estate planning. Because as one parent said to me recently, a general estate plan and a special needs estate plan aren't even the same thing. And that's exactly right. Now, let me tell you about the fourth mistake, and this one's more common than you would think. But before I move to that next mistake, I want to pause here for a moment. If you were listening to this and thinking, but we have a trust, but I'm not exactly sure it does what Jeff is describing here, that is exactly the kind of question worth asking before there is a crisis. My team of planners, we help families think through these pieces and how they all fit together. The financial plan, the estate plan, the benefits picture, the family dynamics, and the long-term care needs. There is a link in the description below and in the top comment where you can schedule a complimentary conversation to chat through this. Now, everything I'm sharing today is educational, of course. Your attorney and tax professionals need to be involved. But if your family has meaningful complexity, you do not have to sort through it all alone. Okay, let's talk through mistake number 4, because even a technically correct plan can fail if no one knows anything about it. Mistake number 4, creating a plan but failing to make it accessible, understood, and coordinated. I've seen this more times than I can count. A family has a beautiful estate plan, documents drafted, executed, trust funded, beneficiary set up, everything signed, sealed, delivered. And then the unexpected happens. Nobody can find the documents, or they find the documents and don't know what they mean. Or they know what they mean, but the key people, be it the successor trustee, the guardian, a power of attorney, don't even know they've been named, nor do they understand the role. For families with a loved one who has special needs, this problem is amplified because the plan isn't just about money. It includes care instructions, daily routines, medical needs, the name of the doctor who understands the condition, the therapies that have worked, and the ones that haven't. If the only person who knows all of that is you and something happens to you, your family is starting at 0 at the worst possible moment. This is where something called a letter of intent becomes essential. It's not a legal document, it's a personal one. It's where you write down everything a future caregiver would need to know about your loved one, including their daily routines, medications, what calms them, what frightens them, what do they love. Frankly, it's one of the most important documents a family can create, and most families have either never heard of it or never took the time to create it. Beyond the letter of intent, the practical coordination matters too. Does your successor trustee know they're a successor trustee? Does your child's guardian know what they're stepping into? Do you have a financial advisor that knows about the nuances of special needs trust? Or are they going to simply follow directions and distribute assets the wrong way when the time comes? Families who get this right treat the plan like it's alive, because it is. They review it, they communicate it, they update it when life changes. And that brings me to my last mistake. And honestly, this might be the most important one that I share today, because this is where estate planning stops being a financial exercise and starts being a love letter to your family's future. Mistake number 5, building an estate plan around assets instead of building it around the person. Most estate planning starts with the question, how do I transfer what I own? It's focused on the assets, the accounts, the property. But for families with a loved one who have a disability, and really for any family with complexity, the question has to start somewhere else entirely. It has to start with, what does my loved one's life look like when I'm not here to oversee and manage it? Because for some families, the financial plan is really just a healthcare access plan with money wrapped around it. And the estate plan isn't just about transferring wealth. It's about preserving access to the supports that make that person's life possible. I'll tell you what I mean. I sit with families who have the trust documents, the ABLE account, the guardianship, everything technically correct. But when I asked, so what does Tuesday look like for your son when you're not here? I get silence. Nobody had thought about it that way. Who helps them get dressed? Who drives them to their programs? Who makes sure they're not just safe, but known? An estate plan cannot answer all those questions, but it can create the structure, the financial resources, the legal authority, and the written guidance so that someone can answer those questions. That's the difference between planning for money and planning for a life. This is where I see families go from anxious to confident, not because they have more money, but because they finally have a plan built around a person, not just the money. So here are the 5 mistakes one more time. A general plan when you need a specialized one, not coordinating with extended family, choosing the wrong trust or skipping one entirely, and a plan nobody can find or follow, and finally, building your plan around assets instead of around the person. If your family has any of these complexities and you want help thinking through how the pieces fit together, I'd love to have a conversation. There's a link in the description and the top comment below. My practice focuses heavily on families navigating these decisions thoughtfully and proactively. Again, this is personal for me, not theoretical and not a day job. So if this resonates with you, reach out. I'd love to chat with you. If this was helpful, please share, like, and subscribe. And I'll see you in the next video. Thanks for watching.